Okay, everyone, this is Tansen Fairmont, the founder of Brilliance in Commerce, and we're starting today with a very exciting new series of information coming from our illustrious speaker, Randall Hillner, and the House of Freedom International Natural Law Trust webinar series. It's May 16th, 2018. We want to welcome everyone. Thank you for joining us. It's going to be an opportunity to hear a little bit more about the other details of the trust not previously covered, as well as the opportunity to allow you to ask your questions. And later on in the program, 25 minutes or so, we'll get into the question and answer, in which case those tuning in by video, computer or smartphone can, click on the raise hand or type into the chat box. And those calling in by phone can press *9 on the phone. Brilliance in Commerce is a project of La Verite, House of Freedom International Natural Law Trust, the Liberty Debt Elimination System, and a variety of other activities and offerings that are forthcoming and current. The International Natural Law Trust has been enjoyed by many thousands of people for generations and has pretty close to a perfect record as far as we can tell. We don't hear of anyone anywhere having any serious problems with it. It just quietly hums in the background and does its work, and everyone is quietly happy with it. So we are quietly continuing with this education series. So today being May 16th, 2018, we're going to spread it out a little bit. So the next webinar will be June 20th, 2018. And then July, we're going to ask you later in the program today as to what everyone wants to do. It's a vacation month for many people, July and August. We will see if we're going to do one that month, and we'll kind of hopefully determine that and announce it in the newsletter. For those who are listening by voice or those who have not been in touch with us before, and you're not already a subscriber to the Brilliance in Commerce newsletter, kindly subscribe. There are a couple of URLs that can lead to that, but one of them is houseoffreedomtrust.com with dashes between each of the words. So house-of-freedom-trust.com, and then click on more, and then newsletter sign up. And then, of course, we have the phone number that goes to our customer service people for those who need to call in by voice, 360-200-7521. My name is Tansen Fairmont. I'm the founder. We have also given me a few titles, Board of Advisors, Monaco Management Group. I've been a speaker on various offshore seminar series and also radio shows, and author of a couple of books. I'm going to move right into Randall, who is our main speaker today. And he's our very much appreciated director of the trust department, and also the founder of House of Freedom Trust, founder of White Light Unlimited, trustee One People's Public Trust, and creator of International Natural Law Trusts. I will summarize very briefly what the trust is about for newcomers, but most of you are already experienced with it, so I won't read all of this. For those who have access visually, or if you're listening to this as a playback and you have it visually on your screen, you can read all the text. But suffice it to say that this is one of the best crafted trusts that has had put into it the best salient characteristics from the trusts that the elite have used for generations. We studied what the Kennedys did, what the Rockefellers, what the Carnegies and Mellons and Hunt families have done. We studied what those who have the greatest protection, greatest freedom, least liability have done. And year after year after year, Randall and his other associates have incorporated these characteristics, and we continue to do so. So the combination of the design of the instrument as well as the intelligent operation of it are what account for its success. So, very good. Randall, we're going to ask you, please, if you could give a basically review, a recap of the last webinar. And let you proceed.
Today, and I have we talked about beneficiaries, I think, last time. I'm not sure. We don't have any. I don't have a signpost along the way, but I'm going to touch upon the last seminar. I'm going to touch upon the last 3 meetings that we've had during this meeting. So let's rather really just proceed, because I think the questions that are on today's meeting will recap what we've talked about in the first 3 or 4 seminars.
Yes, yes.
So, can you hear me?
Absolutely.
Okay, so I'm ready to go forward to today.
Okay. Let's go back to screen share, and I'll go on to the next slide. Do you have that in front of you now?
I have the intro, that's all. All I see is your computer screen right now.
Oh, okay. Let me go back and redo the share. I think I got the wrong screen here. Hold on, folks.
No problem. I'm just relaxing in front of the ocean.
Yeah, it's a hard life, but somebody's got to do it.
Yeah, Mark, you know.
All right. How's that?
That's right on now.
Very good.
So, you ready for me to start speaking?
Yes, please.
Thank you very much, and welcome everyone. So what we're going to talk about today is we're going to recap everything basically we've done in the last seminars, but the main concept of why do you want to create a trust? And especially for anybody with any kind of assets, and especially all of you that are involved with the RV, is a trust is what's going to save you and save your assets from any kind of impact. So what the trust is for is to enhance, protect, and use the assets for productivity. In other words, you want to have the correct trustees that will follow your intent. Your intent is to make sure that your assets are separate from you and protected and put into production. Now, that can be any number of ways. You can do it yourself if you're financially capable. You can hire a wealth manager or any of those others, but you want to make sure that you have the right trustees, and then by doing an irrevocable trust, House of Freedom Trust, you're able to separate your assets, which were yours, and put them into an irrevocable trust with the protection of the trustees, and then have you and the trustees will start to create production of those assets. Now, that also gives you a separation. The assets are no longer going to belong to you. They're going to belong to the trust. Now, this is a little tricky, and if you haven't been too familiar with how it all works, is that the trustees have legal ownership of the assets. However, they have a fiduciary responsibility to make sure those assets are taken care of and used productively. And so if something happens to you, then those assets can't be touched. And as long as you have the right trustees and you have management capabilities, those assets are pretty much out of the touch of anybody's grip. Now, you have to make sure that the trustees are not going to do something where there might be a breach of trust. But basically, that's how you separate it out and into legal ownership by the trustees, but you have the equitable right. So you and the beneficiaries. So you might be the only beneficiary, or you might have your children and your wife or anybody else you want. You could have one of the beneficiaries could be some project that you're looking to help create or support, some cause that you might want to support. So that's how that works. The equitable interest belongs to you and or whoever you want to have as beneficiary. So I basically have done that, and the legal responsibility again stays with the trustee, but you have the equitable ownership and or the beneficiaries. Next slide, please. Okay, what is the trust purpose and what is the main benefit? Well, there's a number of benefits, but primary benefit is that it'll never go through probate. But there's lots of benefits for having the trust. And one is, again, we talked about separation of ownership between you and the assets. And the assets can be managed by you or the trustees or a wealth manager. But a trust never dies. So if something happens to you, the trust would go to its next level of trusteeship. You can have the trustees will carry on and make sure that the beneficiaries are taken care of, whoever they are. You may have future beneficiaries that are coming down the line. You might want to include, let's say you have children and they're married and they're starting to have a family. You may have the future beneficiaries may be their children or grandchildren, and it just goes out from there. The trustees are usually going to be around. If you go before the trustees, then the trustees will make sure that all the beneficiaries are taken care of. If a trustee leaves for whatever reason, or there's a breach in the trust by a trustee, then you can appoint a new trustee and the same thing would happen. So it's all done very intricately through the use of minutes and amendments if need be. And it basically goes on for many generations. It just goes on and on and on. It's like Johnson said in the beginning, is that the Rockefellers and the Kennedys and anybody that's of wealth has used these trusts to continue their benefit. Now, a lot of these people use attorneys and banks to do their trust, but that's because they are involved with the statutory process. So they may have lawyers, they may have banks be the trustee, and that's what we're trying to avoid with House of Freedom Trust, is that it should stay close-knit. It should be friends and or relatives, and thus staying out of the statutory process. Goes on and on and on. Okay, next. Okay, what is the role of the settlor? He is the creator of the trust. The settlor typically funds a trust with his assets. So you folks involved with the RV, is that you're going to assign your currency over to the trust. The trustees accept it. There's one aspect that has to be notarized, and that's the signing of the currency into the trust. That you want to have that notarized so that it's date stamped, and the RV happens. There's a date to show that the trust literally owns those assets, that currency. And then, of course, the settlor is the one who's going to establish the current and sometimes future beneficiaries. Next. What are the roles and duties of the trustee? Okay, this is really good. This is where we start to get into the meat of the matter, so to speak. The trustee will take on the lawful responsibility of ownership. We talked about that earlier. And so they have the legal fiduciary responsibility to make sure that those assets are protected and then enhanced or put into productivity. The trustee owes the trust and beneficiaries a loyalty to enhance and protect those assets. So the trustee literally has a significant role in the process of this trust. That's why it's important to have trustees that you can work with closely, that you enjoy being around, being with, and that you all work together. Now, some of you will think, well, I really want to be in control of the assets. So some people sometimes choose to be a trustee, but that means you need to have a creator that's named a nominee creator. And then if you do that, then you need to have a non-related second trustee. So that's a distinct possibility, but most people say, okay, I want to have two trustees. One is my family member and one is my friend, and I want to be a beneficiary, and I want other beneficiaries, or I want to be the only beneficiary, which is fine too. So when I first started this, my mentor, we worked in San Francisco area, and basically we couples that were established and had an estate, they came in and we created a trust with them, and they created it. They were husband and wife would co-create, and then they would pick two trustees that would take care of the assets, and then they could name themselves as beneficiaries, or they could name their children or any other projects or family members that they wanted to have as beneficiary. So the only stipulation is that the trustee must be 21 and he must have the capacity to hold title and administer a trust. So it has to be somebody that has some savvy into being able to take care of money and take responsibility for the assets. They have legal title, but you as beneficiary have equitable title. Okay, next. Can the beneficiaries interfere with the trustees? Okay, now this is tricky because the beneficiaries have the ability to inquire into the possibility of a breach of trust by a trustee, and that's often sometimes left to a protector, which you can appoint yourself. But they can inquire, but they really can't dictate how the trustee operates in a fiduciary capacity. In other words, it's up to you and the trustees to make sure that this is a clean process, and the beneficiaries can inquire into certain aspects of it but they can't really interfere with that work. In fact, in the trust document, there's a clause, we call it the terror clause, because it strikes heart into a beneficiary who's trying to get his fingers into the trust. And it says that the trustees have a right to take the units of beneficial interest away from that particular beneficiary and then redistribute it to the other beneficiaries. But they do have the duty to not let a trustee participate in any breach. In other words, if they feel that the trustee is in breach in any way, he's not looking out for the assets, he's not looking out for the beneficiaries, then they have the right to inquire. Now, if they don't, if they know that there's a potential breach of trust, then they can be held liable by the trust for that, if they participate in that benefit or by a breach. In other words, if the trustee and the beneficiary are working to sort of sneak in to get some of the assets, then they would be personally liable for a breach themselves. So it kind of puts the responsibility on the trustees to not be in breach, and it puts the responsibility on the trustees to make sure that the beneficiary doesn't participate in any breach as well. Okay, anything else? Questions? Okay, yes. Who's got a question? I love questions.
Okay, everybody. So if you're watching on the video on smartphone or computer, just click on the raise hand to ask a question, or you can type in the chat, or if you're calling in by phone, you can press *9. Okay. Marianne, you are on. Thank you for joining us, and may you please proceed with your question.
Hi, both of you. Hi, Randall.
Hi, Marianne.
Hi. I'm wondering who will solve all these conflicts, if conflicts there are. Do you need a lawyer in that case?
I'm sorry. Would you start that again?
If there is conflict, a breach, who's going to take care of it? Do we hire lawyers or?
If there's a breach, if there's a breach in the contract, then the protector or you can ask the trustee to resign, and if he doesn't, then you may have to bring in the law to step up and do that. But usually, in the document, there is a protector's agreement, and you, as the grantor or the settler, has the right to establish a protector, and then they would fire that trustee that you think is in breach. Okay. And that has legal standing.
Okay.
In other words,
thank you.
Let's say that you there's a breach, you think there's a breach, and you have a protector, then you and the protector would go write a letter to the trustee, and you would say, we think that you're in breach, and we're going to ask you to resign. Otherwise, we're going to, here's your pink slip. You're on your way home.
Okay. Thank you.
Okay, you're welcome.
Well, thank you, Marianne.
Do I have to press something to get off now?
No, I'll take care of that, Marianne. Thank you so much for participating. And Randall, may I add a comment?
Sure.
I think one of the reasons that we've had so much success with these trusts is the quality of the people we have attracted. Mm-hmm. Most people who get involved with these trusts are nice people. Those who are involved in dangerous activities or types of people in the global population that are very dependent on police and courts and jails and the force of government, generally are not attracted to this kind of administration of assets because they know that they have questionable ethics, and they know that they are either criminals or they're involved with criminals or dishonest people or greedy people, and so they want the hard force of the gun behind them, and therefore they're not attracted to this kind of instrument because they know it's very highly likely they're going to have to rely on force, to make people do the right thing. There is a higher civilization that has been around on this planet as long as probably it has existed, especially in ancient golden ages, and even today, with as much corruption as on this planet, there is, I don't know what percentage, but there is a high percentage of our population who don't need to be forced to do the right thing. There are people who answer to a higher ethic that they get from within themselves, and they don't need any big brother to make them be generous or good or ethical. So the whole philosophy of the trust is to hand over legally the control of an asset to someone that you trust. On the other hand, if you are the trustee, then you must be trusted to administer those assets for the benefit of the beneficiaries.
Right.
And in both cases, you are basically obliged by ethic. And yes, Randall has given remedies that are in the law books that a common law or natural law trust can be brought into a court of law, and especially if common law is invoked, the particular actions, not the validity of the trust itself, but the particular actions of its officers can be litigated. But Randall and I don't know of any examples where this has ever been necessary.
You're right, Tanzan. It's not the document itself, it's the ethics of the person behind the breach. So typically, like you said, since working with you and long before that, we have had generally very nice clients. And I really thank all of you for being so generous and understanding what we're doing and what we're giving to you and how we're helping you to protect those assets. And I know, Marianne, you're in Europe. Are you in France or in Britain?
No, I'm in Quebec, Canada.
Oh, Quebec. Oh, I didn't know that. I thought I sent it to France.
No, you're thinking of some other people, I think, but you do deal internationally, Randall. Yeah.
Well, you're a Quebecian. You're not too far away from French-speaking people, I take it.
Well, yeah, that's part of my community. I am actually French.
Quebecian. All right. Good for you. I love Montreal. Yahoo!
Welcome anytime.
Okay. In summer.
Yes, choose the summer.
All right. Well, thank you. Should we move on, Randall?
Yeah.
Thank you, Mariette, so much. Please continue to keep in touch and join us anytime.
Yeah, merci beaucoup.
Merci.
Bienvenue.
Okay, we have a chat question here. If A is grantor and trustee and B is co-trustee and beneficiary is an entity, foundation, institute, business organization, can person A be the founder and president of the entity? That's part one of the question.
That's a little sticky. I would not encourage that. There's not enough separation. So if you're the grantor and a trustee and you're the president of the foundation, let's say, that's wearing basically three hats, and I would discourage that. So you might want to find a nominee settler. You could be one of the trustees. You'd have to have non-related second trustee, and then that foundation, if you want to be the president of that foundation, then yes, that would work, because then you're only doing 2 out of 3, but you don't want to do all 3 hats.
Good. And for the benefit of those who are new to this concept, grantor and settler are used interchangeably.
And there was another part to that question.
The second part is, can person B be the founder, president, executive of the entity? Person B was to review
if the co-trustee is not related to you, then he could be the foundation president, as long as he's not also the settler. It's just shaving it close when you do stuff like that. So it's like the more separation you have from the assets and your projects, it doesn't mean you can't fund the projects that you want, but I would hesitate to make yourself a trustee and then be president of a foundation that's receiving the benefit. That's a little close. But you can do it. You could, as long as you have a nominee grantor and you have a non-related trustee, then the foundation could be the beneficiary. But I would say, rather than being the president of the foundation, that you be in a secondary or co-position as founder, just like being co-trustees.
Okay. Thank you. Richard asks, we intend to establish a manufacturing company within the trust. With the consent of the trustee, can we operate the business independently under the terms of a management agreement?
Sure, the trust can create any kind of business it wants, as long as it's a lawful enterprise. So it could be, it can either be the manager or the trustees that establishes that manufacturing company. In other words, I'm thinking that you as trustee want to have a business, either you as trustee or you as a grantor are going to create a business within, and it's going to be owned by the trust, and that's very feasible.
Maybe another way of asking it is, does the trust dictate how the business is managed?
No, that's up to the trustees and the manager. Right. But I think unless you're going to do the company yourself, more than likely you would hire other managers to manage different aspects of the company. Okay, you're going to have to delegate. If it becomes a significant company, you're going to have to delegate management anyway. And then you, as trustee, would want to really adhere to what the business is doing and watch it from being the trustee that owns it. It's like you're overlooking to make sure the company's doing well and productive and giving back to the trust.
Okay. Next, we have Cliff asking, how do you find out how a country like Brazil will look at a trust? How do you determine if the country follows the same freedoms dealing with a trust as other countries, like no probate, no taxes on transfer at death, no tax on income, and so forth?
Well, I think the right to contract exists in every country except maybe a dictatorship country. But I think in most free countries, you have a right to contract, and that's basically what a trust is. A trust is a contract between three people: the creator, grantor, and the two trustees. So, what were you talking about? The person was from Brazil. I think, I don't know about Brazil. I haven't had a client from Brazil, but I'm working with people in Australia and South America, and now Canada, of course, a number of clients, and a couple of people in Sweden and Europe. So it's the right to contract, I think, exists everywhere in a free country.
Yes, I agree, Randall. It's my understanding as well from what I've heard that generally the same benefits that accrue here in the United States accrue in other countries as well.
Pretty much in the Western world, and I haven't had any clients from, well, I have a couple of clients in Asia, but not anybody in China or Korea yet.
We might soon.
Yeah, we'll take them on. I'll learn Mandarin. Okay.
One party asks, are you taking questions about Liberty Debt Elimination Program? No, sir. Please click on Contact Us on the website and send your question there. We'll be very happy to get back to you that way. We want to specialize in the trust in this program. Okay, the next one is, can protector be reappointed by grantor?
Yes, that's the grantor's job usually, is to have a protector when he chooses. Doesn't have to be right away, but the grantor is the one that would appoint a protector that would be the one that oversees the trustees for any breach, any possible breach. And then he can give a pink slip to the trustee if he considers it a breach, and then he would, the protector would then appoint a new trustee, but it would have to be in the same capacity. If he's a non-related trustee, then he would have to appoint a non-related trustee again, co-trustee.
Okay, and the same person continues, for multi-generational trust, if protector dies or gets sick or resigns, how to set up backup protector or successor protector?
Well, again, if you feel that that's going to be necessary, you can have a list that the trustees would go to, refer to, and establish a new protector. But usually that doesn't really happen. I've never had an experience where the protector has had to step in and fire a trustee. We just on all my 35, 40 years, it's minimal that we've had any kind of activity that goes against a trust or any kind of breaches. It's pretty set up and it's pretty flexible, and you and the trustees have the ability to make slight amendments if it's possible, if it's needed. It has to follow the original intent of the trust, but it can be amended, and minutes can be made that allows for changes to happen. Certainly the beneficiaries are going to change over time. The trustees will change over time. And once the grantor has given the rights or given up, relinquished control of the trust, then doesn't matter whether they're around or not. They may be a manager, and they may come and go, and they may step aside, but it just goes on and on and on. And as long as the intent is held and the trustees hold the assets on into the future, that's fine. And the trustees, if the estate gets large enough, the trustees may say, hey, we need another trust to take care of some of these assets. We want to separate them out again of the trust. It's like you're separating your asset from yourself to the trust, and the trust can do the same thing. It can set up, I just had a client that did this this week. She set up a second trust, and she made her first trust the grantor, and then it went on from there.
It could be that some trusts would have some reason for having a lot of trustees, and maybe there could be more reason to have a protector. Like some universities, they have 30, 50, 100 trustees, you know.
Sure. But that's usually very statutory.
Yeah.
So you can do that. You can, I think on a personal scale, you're not going to need a lot of trustees. I mean, if you're running a college, that's one thing, or a huge foundation. That's a board of trustees. But typically for your own personal use, you only need the 2 trustees. You can appoint a third trustee, then you would need a majority. With 2 trustees, it's a unanimous decision to make any changes. If it's, act on a decision to do something with the assets, then it takes a unanimous decision with 2 trustees. If you have 3, then it would just be the majority.
Do you think that this kind of trust would work well with a big institution?
The bigger you get, the more involved it is. I would say it can work, but if it's really huge, you're going to need a lot of trustees and a lot of management. I would have the trust be the holder. I would create a company, a holding company or an LLC or a foundation that would run the business, and the trust would just be the beneficiary of that process. Again, going back to being a beneficiary on this, somebody said they wanted to set up a company. The trust would be the beneficiary of that company.
Makes sense, because the larger the number of people involved, the less likely it is that they're all going to be educated on natural law or common law.
Right, and they have you want to hire those people that are savvy to what the business is doing, not necessarily. They don't have to be savvy to the trust work. Just you and the trustees. So you're going to hire managers for all your different projects, and then the benefit is coming to come back to the trust. So what goes out from the trust can get as large and as complicated as you would like it to, but ultimately you want to keep the trust really simple, just between you and the trustees and any beneficiaries that may go along. And over time, it may, I've had young couples that create the trust, and they have children, and along the way, the important thing is that they tell their children that this is how this whole asset protection aspect with our financial process works. And they basically teach the children to come up with the understanding of the common law sovereign trust.
I like it. It makes it seem like it's the crown, it's the peak, it's the summit of any group of people or asset structure.
Absolutely.
And if you ever have to deal with large numbers of people in the mainstream, then have an entity under it that is statutory and deals with the public in that way. Yeah.
Yeah. You have a storefront, and then you have the back front. Or the back. You have a storefront to present yourself or your project to the public, and then the trust just stays in the background.
Right.
And that can be another trust, or it can be an LLC. depends what country you're in and how they operate on a business level, and so it varies. But in the U.S. particularly, and I think in Canada, I would think also I have people in Oz that operate the same way. They have a storefront. Sometimes it's trust itself if it's a small process. Sometimes they create another business entity, and that does all of the work. It may interface with the public. It may interface with the government, and then the sovereign trust just sits in the background, stays mute.
There's a last part of the question from the same party who said, must backup successor trust protector be set up while the grantor is alive, or could it also be done somehow after the grantor dies?
Well, I would think if the protector, if the grantor dies, then the protector, let's say he wants to step aside, or he's getting he can't be in that capacity, then there would be a list that the grantor leaves that he can appoint to be the next protector. So that would work. And then, but once the original grantor dies, then it's up to the trustees to carry on. And if there's in fact a breach, or the protector goes away, then it's up to the trustees to either appoint a protector, which they probably won't do, but basically they have the fiduciary responsibility to carry on. And the beneficiary can always come in and inquire. If they think there's a breach, then they can inquire, and legal action can be taken against the trustee.
An example might be, let's say that the grantor designated that the assets be distributed to a children's hospital. The grantor passes away. The trustees decide, I think we're going to start gambling the trust assets in the local casino, so the protector can take action on that basis.
Right. And the grantor could appoint one or two or three successor protectors.
Mm-hmm.
If something happens to the first protector, then the next one can be established. But see, the protector's there to protect the grantor. In your origin, let's say in particular, when we started that way, the couple, the person that's setting up the trust, chose a protector because they were the beneficiary. And now we're talking about the passing of the grantor and the passing of the first protector. Then there could be a second protector, successor trust, a list of trustees. Maybe the grantor says, I would really like to have these people be future trustees and these people be future beneficiaries. It can be established beforehand if that person wants to.
And after a couple of 21-year renewals, future generations could decide whether to continue the trust or dissolve it and form a new one.
Well, they keep on going. They renew the trust, and if they want to dissolve it, then it's dissolved, and whatever assets are left in the trust is equally given out to however many beneficiaries there are on a prorated basis, depending on how many units that they hold, etc. But that's down the road. But we're talking 21 years plus lives. I mean, the statement in the contract in the trust calls for 21 years plus lives in being. In other words, it's not only 21 years from this date, but it's 21 years from the lives that are already born in that as beneficiaries. So you may have children be beneficiaries, and they may have small children, so it just automatically go beyond that. until those lives in being come to the end of 21 years, and then it would be renewed. So it really has a long life as it is.
Thank you for that clarification. Okay, James writes, is it usual for the IRS to question the EIN application for a number of trusts by the same settler? He says,
I've never had that issue.
It has happened when I, along with a number of friends, used the one settler who applied for the EIN.
I've never had that issue. In the early days, for a number of clients, I put my name down to apply for the nominee grantor, and then I applied for the EIN number, and I never had a problem with
that. A related question might be, is the settler always the responsible party that is designated?
Not necessarily. The trustee could be the responsible party. They could use, a trustee could use his social security number to get the EIN. It depends on, really depends on the grantor and the two trustees. But somebody's got to do it. Somebody's got to be a responsible party and give their social security number.
Right. And so, James, it's a good question, but no, Randall and I don't think any of us have ever heard of that being a problem. And then James continues, is it more recommended for the settler to apply for the EIN?
Typically, the settler would do that right away. When I send out the documents, even before they're signed, the grantor can go right online and apply for an EIN number and have it ready to go when he's gotten all the signatures back. And he would be the responsible party. He would list himself as the responsible party, and the trustee would be in the position of trustee at the top. The SS4 form, if you look at it, has the name of the trust and the address, and then the trustee, and then down halfway through there's the responsible party and the social security number.
And the last part of his question is, also during application, the IRS states the trust must file a Form 1041 each year. When there is no filing ever done, will the IRS ask questions on why there is no filing taking place?
You never file, there's no question, because they're not checking on EIN numbers. Really, typically the only way that there's any inquiry by the IRS is if you file once, you have to commit to it, because they're going to just keep coming back to you and saying, where's your 1041? You filed already. But I've never had an issue with the IRS knocking on a door where people never filed in the first place.
Same here. I'll just follow by saying the only rights you have are the rights you know you have.
Yep. And there's ways to address the IRS when they inquire.
Yes. All right, so the next questioner writes, can grantor change beneficiary or reserve the right to add or remove beneficiaries, meaning add or remove beneficiary after the trust is set up?
Yes, absolutely. That's an ongoing process.
At any time?
Anytime, because beneficiaries will change. Maybe there's children happen or grandchildren happen, and the grantor has the ability to add or subtract names that they choose to do. Let's say you have a wayward person and in your family, and you at some point you gave them beneficial interest, but they're getting a little out of hand, and you can just say, okay, we're taking away the beneficial interest for a period of time until you get your life together. So
I'm going to add a further question to that, because as you know, the settler, also known as grantor, signs off at the beginning of the trust and has no further control over it.
As grantor, yes.
As grantor, right. and meaning that same person can then adopt another role and play and put on another hat. But
Sure.
That person is signing off as settler grantor. Therefore, when a beneficiary is added or removed, who signs on that minute?
The trustees would sign on that. It would be basically, well, see, because if the grantor he gives up control of the trust to the trustees, but he can still be the manager, and he can still say, okay, I want to, here's a list of particular beneficiaries, and we have a clause in the trust that says if this wayward son or daughter can't handle the beneficial interest, then I would like to have it taken off. And that's can be a preset condition.
In other words, it's the fiduciary responsibility of the trustees to follow the wishes of the original grantor.
Yes. And typically after your first official minute, then you're going to sit down with the trustees and you're going to say, okay, this is what I'd like to see happen in the future if something happens to me. And have a list of potential trustees, future beneficiaries, and it's recorded in the minutes. And you and the trustees would sign that. So it's a legal process within the trust.
Okay. The next question comes from Cliff, and this one, I believe, follows on that question about foreign countries. He said, how would you find out or contact a lawyer in that country?
I guess you look in the phone book. You mean a common law lawyer or any lawyer? Lawyers are all over the place, unfortunately.
I might just add that it's important to realize that especially statutory lawyers are, not only, they're worse than useless with these entities, with these instruments. They're not educated in them. They don't think like trust writers think. And so generally lawyers are neither needed nor are they useful in any country for these trusts.
Well, there's always been lawyers around and there'll always be lawyers around, but it doesn't mean you need to resort to them. But if you do, for some reason, then they're there. So unless you have a common law court in your city, in your district, if there's any legal action that has to take place, then you're going to need a lawyer to go before the bar. So that there's advantages and disadvantages, but I've never had any of our trusts in a court of law.
Generally, it would be for an action, not the common law nature of the trust itself, but the action of one of its trustees or officers.
Yes.
That would fall under certain jurisdictions.
Well, and you got to remember that let's say you've put your assets into the trust and the trust has bought a house for you to take care of. You're the housekeeper. And it's up to you and the trust to make sure that there's sufficient insurance on the property and the taxes are paid on the property. And if somebody comes on your property and you have minimal insurance and there's some accident at hand, then that person may turn around and get a lawyer to sue you or whoever owns the property. So you have to be ready to use a lawyer in some instances. But typically, if you're careful and you have the right insurance and you're savvy, you won't ever come across that. That's why you never put a car into the trust, because a car is a liability, or a boat, or a jet ski in particular. It can create a liability, and if the trust owns it, then the trust is going to be sued, and you don't want that. So never put a liability in with your asset.
I would just add too, for the benefit of everybody, and let's repeat this in the future to remind, because we get a frequent stream of people asking about, well, what do I do if I need legal help? Keep in mind that Brilliance in Commerce, House of Freedom, and we're joining forces with Lighthouse Law Club and Monaco Management Group. Between us all, we have an international network of legal experts in multiple countries who are some of the best in the world. Okay, so on our website, you'll see how to win in court. You can click on that. You can also click under more, and you'll see about our legal team. And then Lighthouse Law Club also has its own network, and we're joining forces with them. So you will always have access to legal expertise, whether it be a bar licensed attorney or whether it be a paralegal, which many times is much better.
Right.
Because when you have somebody who doesn't have a license, they can be more powerful, more effective, and more potent to give you a win than often a licensed professional.
Right.
Because they're not afraid of they don't have a license to lose. They're not afraid of losing it. And yet their legal expertise can be as good or better.
Right, and they can still do the same paperwork. They can do the paperwork that any lawyer can, but they don't have to worry about the bar. And all you have to do is go to the county courthouse and put in the paperwork, and it's as effective as having a lawyer represent you before the bar.
You bet. I knew a man once who he got his JD degree, and he was in the middle of taking his bar exam. And when he got to the question and the answer, and he saw where he was going to have to sign that he was loyal to the court and not to the client, he got up and walked out.
Yep.
He had a conscience. He was one of those rare people with a conscience. No way he was going to pledge his loyalty to the court.
Yeah, well, it takes a certain breed to do that, but there are lots of them out there.
Yep. We've found many of them. Okay, so Mark writes, in the event the natural law trust has only our pre-valued currency as its asset, and the currency revalues and the bank accounts that hold the proceeds, and there are sub-trusts created to now handle business, humanitarian, and family operations, must the structure of the sub-trusts be the same as the parent natural law trust, or can we create new trustee, grantor, and beneficiary setups?
Yes, absolutely. The parent trust, and this is what I did with a client this week, had her first trust be the grantor, and then she chose herself and a non-related second trustee, co-trustee, and then she had different beneficiaries. So that's easily recognizable.
In other words, it's up to you. There's no requirement that it has to have the same.
No, but you really don't want the same. You want to make sure your focus is on the assets, and the RV is going to present a whole different process that's going to evolve. The banks are going to change. I mean, there's all kinds of chatter. So we'll just leave it at that. But yes, the value now is, let's say you've got $1,000 in foreign currency that's worth that only. And then the RV happens, then that new currency is going to explode into significant sums of money. And you're going to want to look at whether it's in the right bank, whether you want to break it up into different accounts. You may have an account for one currency, you may have another account for another currency, etc. So it goes out from there. And as the assets grow, you're going to have different banks and different accounts for the growth in your prosperity.
All right, next question. In the case the trustee and the beneficiary are the same, do two trustees require two beneficiaries, or two co-trustees and one beneficiary okay?
Sure. Yeah, you got to have two trustees. I mean, you don't have to. You can be the sole trustee and have your children, grandchildren be the beneficiaries. But the bank oftentimes won't open an account unless they know there's a successor trustee available in case something happens to you.
I think he's asking if he's trustee and beneficiary.
Well, as long as there's second, no, you can't be the sole trustee and the sole beneficiary.
So if he were a trustee and a beneficiary, then it would be required to have additional non-related trustees and beneficiaries?
Absolutely.
Yes. Okay. I'm reviewing down through the questions here. Let's see. I think this next one was already answered. Okay, here's one from James. Can one of the trustees be the manager?
It doesn't need to be the manager because he's already a trustee. The manager is a secondary position to the trustees. So if you're a trustee, you wouldn't need, unless you want to take on the name of executive manager, your trustee has more power than the manager.
But if you had multiple trustees, you could have one being called the managing trustee, I guess, yeah?
Oh, sure. You guys can call anybody else names that you want.
Good answer.
Absolutely.
All right. How is the trustee compensated? I.e., can they benefit from the successful operation of the business or just direct the profits as directed?
Typically, let's start at the beginning. Typically, the trustees work for, depending on how much activity, they went to a trustee meeting and then the trustees were taken to lunch by the grantor. And then if you're doing a lot of activity, then trustees could be paid a salary commensurate with the amount of work that they do. If they have financial savvy, then they would be paid for their financial advice as well. Two separate things. And it just goes on from there. And the more work that they do, then the more salary that they should be paid. They should have an equitable value come for the exchange of their energy. In the early days, people didn't want to be trustees because it was required that they didn't receive any money in the early days. So now it's okay to receive a salary both as manager and as trustee. Is there
anything unethical about the trust giving the trustee use of things that the trust buys instead of paying all of it in cash? For example, the trust owns real estate or cars or
sure.
Yeah, and just let the
sure.
trustee
the trust could pay, let's say, has a substantial estate. The trust could lease 3 cars, one for each trustee and one for the grantor. And the trust would pay for it.
Right. Marianne in Quebec, did you have another question?
Yes. I want to know what EIN means.
That's a term that's used in the U.S. for the banking purposes. And the banks down here, and I believe it's the same in Canada, is you're going to have to get a number.
Business number in Canada.
Well, we have two options. You can apply for a foreign grantor as a foreign grantor trust, and you can have an EIN number from the U.S. that you use in Canada. Otherwise, you have to go to the Canadian Revenue Service, and I think they don't have an online program. You have to do a mailing process. I'm not sure, but I know a couple of clients that we've had in Canada. Some have applied for a foreign grantor trust EIN number, and others have gone to write up how they went to the Canadian Revenue Service to get a number from them.
It stands for Employer Identification Number, and it got started a long time ago when most businesses had employees, and so they just called it the Employee Identification Number. But it has, by default, become the Business Identification Number in the United States. So they just use that for all business registrations, even though the trust may or may not have a business.
Right.
Okay.
Well, it's the banks that put the...
They will require it, so they'll know where to send me, like, for example?
I don't know why the banks require the number. It got weird after a while. You didn't need one in the beginning, and in the beginning when I started, you didn't need a EIN number, but in fact, the bank would allow the manager to sign on the account line as well. But now it's gotten really strict, especially the bigger banks, and they want to have the number, and they want to have only the trustees sign. So I don't know exactly what it's like in Quebec. You're going to have to look at that, but I think we've got a couple of clients in Midwest Canada or somewhere up there, and I walked her through her process just probably 3 or 4 years ago, so I don't remember exactly, but she just filled out a form and then had to mail it in, and after I said, if you have any questions, then call me back, and she never did, so it must have gotten their number, and
yeah.
I guess the banks up there are requiring a number now also.
Okay, we'll find it. Thank you.
Okay.
Thank you, Marianne.
Yeah, Marianne, I think you could just Google what the Canadian Service needs.
Uh-huh.
Okay.
What Canadian Services need for a trust, right?
Well, for yes, to get an EIN number or a similar number for
what does
a
it stand
trust.
for, EIN? Tell me what.
It's the Employer Identification Number, but that comes from the U.S. when the company had lots of employees.
So, Randall, is it your understanding that anybody from any country can go online and get the EIN from the U.S.?
If they have an address that they can use, they have a friend or a relative in the U.S.
They need a U.S. address?
Yeah.
Okay.
You're going to have two addresses. You're going to have the address where the trust is going to reside. So if it's in Quebec, it would be there, whatever that address is. And then the local, the way to get the foreign grantor trust number is that let's say you have a friend in Vermont just over the line, and you would use their name and their address to file for an SS4 form for foreign grantor trust in the U.S. And then you would have that number, and you could use it for the banks in Canada.
Okay. Okay. Now that you're saying that I need an address, I do have an address obviously here, but I don't think I'm going to live here long. So my trust is with this address. What happens when there's a change?
Well, it's not a problem. The trust is a document, is a paragraph in the trust that allows a trustee to change addresses at any time, anywhere.
You need to go to the notary for it?
No, you just leave.
No, okay.
You know, you just move. Let's say you decide to move to France. You just leave and the trust goes over to France, and then you will have to, you want to get an account over there, you have to inquire as to what's needed in France or wherever you go.
Okay. Thank you.
You could become a maniac, you know, and you just pick up and go across the border and go from there.
Have to be crazy for that.
Those crazy Quebecians, you know, you never can tell.
Crazy all over, right?
Okay, anything else? Anybody else?
Yeah. Okay. Thank you. Merci beaucoup, Marianne. So,
Bienvenue, Randall.
Okay.
So we have, if the minutes of the trust are not notarized and there are no witness, would a fingerprint of the signer next to the signature be sufficient?
It may, but I would just get 2 witnesses also.
That is a tradition in law, yes.
Yeah, 2 witnesses. We used our thumbprint all the time for the OPPT, but there was always 3 of us, and if we needed witnesses for anything, we could do that. But thumbprints work, but it's better to have a witness or a notary.
Randall, I don't know about everybody else's screen, but sometimes only the top half of your head is showing in the camera. So there you go.
Stop stooping over.
All right. The next question is, when the trust requires restructure, splitting up or set up sub-trusts, who gets to make those decisions? The trustees alone or need to have beneficiaries agreement?
Well, is the grantor still around? If the grantor is still around, there'd be the grantor that would be making that decision. But if the grantor is not there, then the trustees would make the decision to split it up and open up new trusts or create new trusts. And that, in that case, it would be the trust that's creating the new trust, and they would have to have new trustees as well.
Okay. Okay, I'm going down through the questions here. Let's see, what else do we have? Addressing the issues dealing with opening bank accounts for the trust. This is from P. Anthony. In the future, is it possible for you to provide or compile a list of recommended financial institutions that open accounts for the trusts and have this list available only to those who purchase one of your trusts?
It's a local level thing. Wherever you live, you need to work with a bank that you feel comfortable with and that will open up an account. Sometimes you have to go to 1 or 2 banks before, and you always take the trustees with you, but you may have to go to a couple of banks before they'll say yes. Once you do, then you can, because of electronic banking now, you can use that trust account, well, that bank, you can use electronic banking with that bank anywhere you go. I have a Wells Fargo account, and there's no Wells Fargo here, but because of electronic banking, it's not a problem.
So yes, I would agree and add, Randall, that we're probably not going to publish a list like that because the question assumes that it's so rare to find a bank that'll open such accounts, and it's not so rare. It's actually very easy. Most banks everywhere, most communities everywhere have a bank somewhere that'll say yes. And like Randall said, you only have to try 1 or 2, maybe 3 before they'll say yes. And generally the ones that say yes turn out to be the best ones anyway. It's not that hard to find them. So no, it's not necessary to publish a list like that. Although we are hearing about more and more banks that will open accounts online remotely. So
Right.
we're sort of in the process of investigating those, and if we come up with some of those, we will publish that, or at least make it available to trust clients.
Sure.
We've
Yeah.
heard about one in
We
Florida, one in
I think
London,
we have
HSBC,
HSBC does. My one of my clients just opened up an online account. You
meaning they
have
didn't have to show up in person.
no, just went online, filled out the forms. I think they clicked in. They had a short phone call, and it was done. So
They must be getting
Tiger,
desperate
on
for
the other
business.
hand, is really stringent. This bank in Florida has an online service. I think there's probably a number of banks now that do online, open up an account online, and just have to supply the right numbers.
Mm-hmm.
And yeah, when we find that, I know that HSBC does, and this bank in Florida, and we'll try more. And as we come upon those, Tanzan can put them on his webpage, or make it available to clients only.
Right. And also, we can mention that a professional trustee service is forming.
Yes.
So Randall and I and Mark at Lighthouse are involved with that. And we have had options in the past for professional trustee services, but this is going to be a bit better organized with more possibilities and more service points around the world. So that's forthcoming, which means that Natural Law Trust clients will have three choices for who to appoint as trustee. That would mean either...
No, I think it's going to be more that it would be our group would be one trustee. So in other words, MMG would be your second trustee rather than one of us.
Okay.
I think it's going to be a group effort, and it's better on a professional level to have the group behind you than just one trustee. Because if something happens to one of the trustees, then the group still exists and can still be your trustee.
And so the clients would still be encouraged to either be their own trustee or appoint a friend or family member as one?
Well, you still want to have two trustees. You want to have maybe a family member and us, or you want to have a friend and us, our group. So it would still be as a co-trustee.
Right. Okay. The next question is how to get a bank account in Hong Kong, Singapore, and Zurich. Need address and tax ID from these places? Can the same natural law trust hold bank accounts in different countries or use different trusts, one for each country?
You just have to inquire into the particular bank. If you have a connection with a bank in Hong Kong or Europe or anywhere, then you have to walk in the door and go from there. I don't know what they would require.
Randall.
It seems like most of the free countries in the world are following, obviously being thumbnailed underneath the U.S. and the way they operate. So you'd have to abide by the banking process in that country.
Randall provides the list of documents to take into a bank to open the account, and that same list of documents I would think would apply to any country in the world, yes?
Yes, and you definitely want to take your trustees with you, especially in the U.S., probably Canada too. And you need to take those that particular paperwork, absolutely. But some banks will want to see the whole trust document, and it's okay if you say you can't copy it, you can look at it, and especially the minutes you don't have are not your business and they're private, but you can leave them a copy of the memorandum, or the trust abstract can stay at the bank.
And the last part of his question was, can the same natural law trust hold bank accounts in different countries or use different trusts, one for each country?
Sure, it's an option, but it depends on how big your estate is, and
Right.
whether you want to break it up into different trusts or whether you want to just have different accounts.
Yeah, the cardinal rule of asset protection is never put all your eggs in one basket. So yeah, one trust can have 10, 20, 30 different accounts, but if the assets are large enough, you may want to have 10, 20, 30 different trusts.
Sure.
So it's not determined by where the bank accounts are.
No, I think it's the need, what your need is.
Yeah. The next question is, when the grantor transfers assets to the trust, how many units of beneficial interest are given to the grantor?
It depends whether they're the beneficiary or not. They may be one, or they may be the only beneficiary. So it just depends. They may have themselves and their children and grandchildren already marked out. Some of them will put themselves down for a minimal amount or major amount, and give minor amounts to their children and grandchildren. It's totally up to you and what you want to do with your estate. And these are your assets. You can reap the benefit of that, or you can pass it along.
You want to give an example? Like in what instance would, say, 100 units apply?
Well, you are alone, but you have 2 children and 2 grandchildren. So in the beginning, you might say, I'm going to take 50% of the beneficial interest myself. I'm going to give 20% each to my 2 children, and the other 10% is split between the grandchildren, 5% each. And then when the grantor passes, he may say, when I pass, then the 50% is broken down this way, and it would be ratioed out accordingly. So it all depends, and that's an individual. Whenever I work with a client, I say, well, how do you want to see it go out?
Okay, very good. Thank you. I guess that covers that. Let's see the next question. And if the trust is dissolved in the future, will the assets be redistributed to the grantor because he has a certain unit of beneficial interest?
Well, wouldn't be dissolved. Typically, you wouldn't dissolve the trust. Why? I don't. That kind of doesn't make sense to me. You would keep the trust going as long as you're alive, and as long as your beneficiaries are alive. That's why you set it up in the first place. The only reason it would dissolve is if you're long gone and your children, there's too many beneficiaries. Sometimes trustees say, hey, this is getting to be too much work, and we're going to dissolve the trust and prorate out all of the assets in it to all of the beneficiaries that are left.
Okay. One writer writes in saying, professional trustee service sounds awesome.
Yeah, we're going to have fun.
Okay. And then James says, will a building society open a trust account?
A building society?
Mm-hmm.
I need clarity on that. Is that a company or?
James, if you'd like to speak verbally, maybe you can clarify your question if you want to raise your hand.
Um, is it a new society that you're talking about, or something that exists, or are you talking about a company or a title? I would need to know that.
I guess a blanket answer could be that just about any kind of business or project can hold its assets in one of these trusts. There's really no limit
Sure.
as to what kind of humanitarian enterprise it is.
No, in fact, clients now that are mostly involved with the RV are coming in and they're going to put their project as the beneficiary.
Mm-hmm.
They may put themselves and some of their family, and then they put the project as well as beneficiary.
Mm-hmm. Yeah. All right. And then we have, I believe this must be Antonio. Is a savings and loan in the UK and building society similar to a credit union?
Well, if it is anywhere near it, then it's fine, because I have an account with a local credit union here as well, and any banking institution would qualify.
Mm-hmm. Right. Now, I had one credit union a few years ago turn me down on opening an account, not because they didn't like the trust, but because I had not been a borrower and I had no credit score as a signatory. So credit unions deal with credit, and they wanted a credit score, you know. So each institution has its own reasons.
Yep, I've never had that experience, so that's a new one. Anybody else?
Okay, so this question is, if we set up a natural law trust, where did it go? If we set up a natural law trust with a down payment, can we use the trust to do the currency exchange before activating it? Now, keep in mind that at Brilliance and Commerce, we're phasing out the down payment unless it's attached to a installment plan, meaning $250 a month for 10 months until your trust is paid off. We're just in the process of installing that on the shopping cart. But yes, absolutely. I guess, Randall, they can do the currency exchange as long as, but they have to understand they can't open the bank account necessarily.
Right. So once they sign on and put their deposit down and commit, then they fill out the form, and they can email questions beforehand. And then if there's any question on the form, I can help them finish that. And then I would send an abstract out right away. And that abstract is a memorandum of trust, a trust certification that means it's real, the assignment of your foreign currency. Now, the trust certification and the addendum need to be notarized, but now I've got a notary page, so you get the trust abstract, the memorandum, and the certification and the addendum, and then you get the notary page that says this is to notarize signatures for the memorandum and the certification and the addendum. So it's dated and stamped. Okay. And then when you finish paying, then you get the whole trust. You will be able to go to the exchange and exchange your currency before you get the trust, but you won't probably be able to open up a bank account unless there's significant change in the banking system.
Right. And so the title to the currency can be given to the trust.
Yes.
While it's still unactivated.
Yes.
And just about everything else done except the full operation of the bank account and so forth.
Right. And you'll have an EIN number, especially in the U.S. You'll have the EIN number, you'll have the memorandum and the certification and the addendum A. And that'll get you in the door for the exchange, but it won't allow or won't get you to the into the bank account system unless you happen to have an account already. But I would hesitate. People want to go right away and go to the bank and open up an account. And I say, what for? Because the bank is going to charge you $20 a month just to have a checking account sitting there. And you don't need it until the exchange happens. And then I think from my intel that I've been collecting along the way, the banking system is going to change somewhat, if not significantly. I don't know.
It's already happening. So we have several comments, both from Antonia. Thank you for joining us, Antonia, by the way. For everyone's information, Antonia interviewed me a couple of years ago on her radio show. And also James about the building society thing. She says a building society is what it is called in the UK, a savings and loan or credit union. And James says, can't see where to raise my hand. A building society is much the same as a bank with savings and loans. So,
fine.
Yeah. I guess the question being, will the trust work with them?
Well, it depends on them and how prudent and how you present yourselves, you and the trustees present yourself to the bank or the society. That's typical. I mean, especially now, as they want both trustees. I tell every client that goes into the bank, I said, take both of your trustees, or at least one. And that's a much easier door to open than to go in by yourself as manager, unless you happen to be a trustee.
It's looking like we're going to be more involved with UK people with our collaboration with Lighthouse Law Club. There's going to be a lot of UK business coming in.
I love it. We'll take it.
So this questioner, P. Anthony, says, I already have an account with a credit union, so it should be easy for me to open a trust account, right?
Sure. And I've opened up trust accounts first and then had a private, my own personal account as well.
My own experience has been that if they know you personally and you have an established relationship with that institution and you're in good standing, it's more likely that they would open the trust account for you even if they don't understand it, because they know you. They've done their KYC on you. They're comfortable with you.
Yeah.
Mm-hmm.
Again, it depends on the institution.
All right. Paul writes, can a trustee become the beneficiary if something happens to the original beneficiary?
Sure. If that's the intent of the grantor, then yes, for sure. Can be a future beneficiary.
And would it be necessary to have additional beneficiaries?
No, but you're going to have another trustee.
Right.
I don't know. I would have the trustee consider setting up his own trust.
Mm-hmm.
Unless the intent of the settler is to have that trustee also be a beneficiary in the future, or maybe even present time.
Right.
In other words, if you get a nominee grantor and you are one of the trustees and you have a non-related second trustee, then you could be a beneficiary, but I would suggest that you not the sole beneficiary.
So as to reduce confusion, I'm going to throw at you, Randall, 4 different words that have been used: creator, settler, grantor, and exchanger. Would you like to comment on the synonymousness? Is that a word?
Yeah, synonymousness. I love that. That means I can hide under the covers. I'm synonymous. I'm synonymous-ness. Um, yeah, they can be typically grantor, creator, and settler are what the terms we use. And um, we're starting some other process where we're going to call it the exchanger rather than the grantor. It's just a terminology, but in the end, they end up being the same.
Hope that makes it crystal clear. And the next question is, what's the difference between a memorandum and an addendum?
Good question. The memorandum is a synopsis of the trust. In other words, who the creator is, that they appointed trustees, which trustees' names, what it's going to do, what some of the powers are, what its capabilities are. And so it's a brief scenario, it's 2 pages, that tells anybody looking at the abstract that this is what this trust is going to bring to the table. The trust certification is just for the trustees to sign, and that's where they certify that this to the bank or anybody else that this trust is been established at this state and it's has these certain qualities to it. And then the amendment is amendment to Schedule A, and typically Schedule A is for personal property that you already have, like jewelry, things that have value that you put in the trust, but it's not the currency. I want everybody to keep their currency separate from the rest of their assets. So I create an addendum A, and that's where you would list the different currencies that you have, and then you need to date stamp that. So it needs to be notarized.
Good. Thank you. All right. PA says, Randall, this is a catch-22. If I have an abstract and then no bank account, how do we get the money to pay you to finish the trust? I am a trustee, or shall I put the currencies into an LLC, and can I then move it out to the trust?
Well, I would just pay out of your own pocket for now, and then when the exchange happens and you can get the rest of the trust, and then you can pay the rest out of the trust account.
They're saying if the trust doesn't have a bank account, then there's no account into which the proceeds of the exchange can go.
Yeah, well, you'll have the money, and you'll need to figure out how to get tons in the rest of the funds so that you can. I mean, by then you'll have a credit rating with the exchange people, and they will give you a certain amount in your own name or however you want it, and then you would pay for the trust. You get the rest of the documents, and that would be given to you right away so that you can then go into the bank.
Right. That's what I've suggested in the past when this question has arisen, is perhaps just have the exchanger give you $10,000, for example.
Right.
Right. In your personal name, pay off the $22.50 or whatever's remaining for the trust, then open the trust bank account, and the rest of the hundreds of thousands or millions or whatever you have can go into the trust bank account.
Right. Yeah, it's a little tricky, and you're gonna have to put out of your pocket before you can really get the account open. But I think at the exchange, wherever it is, they will give you a certain amount of cash available, and then you can put it on your card, or they may give you a loaded card that's ready to go, and you can use it to fulfill your financial needs for a short period of time till you get the whole trust document. Then you can open it up from there.
All right, next question. I know you're collaborating with Mark from Lighthouse. He spoke of non-traditional alternative private banking institutions. Are you familiar with these?
Yes. In fact, I have a couple of people that are going to open up a private bank here in the U.S. once the RV happens. So yeah, I think what will happen is that that's one person's project. Mark is going to have it going. There are probably a couple of projects ready to go that once it happens, they're going to have a private banking system available.
And I think he mentioned a relationship with the Republic of Georgia, and a private payment system. So that would be a
Sure.
question more to address to Mark, but yes.
Yeah, I think it's going to change a lot of things when the RV happens. I just
Yes.
read an article today Intel about already in Iraq, they have exchanged the Iraqi dinar. It equals the denomination. They're starting to print $1, 5 dinar, 10 dinar, 100 dinar. And it's equal to the US dollar. So I think that's how close Iraqis they have billboards all over the country to say, go in and exchange your dinar for the new denominations. And so that's a sign that some things are getting close.
Likewise, the cryptocurrency world is just booming and building just in huge ways. I'm reading that the biggest banking institutions in the world, including central banks and governments, are jumping on board big time.
Sure.
It's going to become mainstream pretty soon. In fact, this year, it's expected that the big institutions which couldn't invest in them before will be able to do so. And some of the big online storefronts like Amazon will start accepting them.
Right. Already certain automobile makers are accepting cryptocurrency, and it's going to take off. It's going to be really different.
All right. This question might be the last one for the day, Randall, and we should wrap it up here. It's getting close to 6 on the West Coast. And we want to put a question out to those still remaining with us as to future webinars. But this question is, who issues the certification of the trust? Is there a fee or included in the $2,500 fee?
That comes with the abstract. The abstract contains the memorandum and the certification and the addendum A for your currency.
Right. So no, there's no extra fee for it. It's included. Both
that comes right away in the trust abstract.
Right. Both with the unactivated and the activated trust.
Right.
He says
the reason Tanzan and I decided to do the unactivated so that people could get their currency and have a notarization that there's a real trust and get their EIN number, because you're going to do that right away as well. And then you get it notarized, and then it'll be ready to go to the exchange.
Okay, he asked another very good question. Please clarify, what is non-related person for trustee and beneficiary? By blood, work, employee, what?
Yes. Blood, marriage, employment.
Living in the same household?
You can get away with it, but I know if they're not related to you, they're not related to you by blood, marriage, or employment. If they're living in your household, then you've got some relationship with them, but if it's a good friend and you trust them, then that person could be the co-trustee.
Okay, I think that answers that. So perhaps we can do this, Randall, and that is discuss next month, July. Would you like to explain what you were thinking of?
Oh, seeing that's about 6 weeks away.
Excuse me, I meant to say 2 months from now. June 20th is our next webinar.
Right.
And then July, we were wondering what to do.
No, it'll take me some book delving to see what maybe we haven't covered yet. And I got to go back to your frequently asked question page and see if there's anything on there that I can expand on. So I don't think that far ahead. I'm dealing with clients now and just focusing on them.
So the question is whether everyone would like to take vacation for July or continue the series because there's too much interest to not continue it.
Right. Well, I would, if you have any feelings whether we should continue every month, I put the suggestion out there that we maybe do it every 6 weeks, but I would, give Tanzan and I some feedback.
Well, we have one chat comment here saying continue. I guess the question is, do we want to create it being monthly like we have been, or start doing it every 6 weeks?
Right. And I would just send your vote into Tanzan, and he can say, hey, we got a lot of interest and let's keep it going every month. The reason I moved it, we were going to do it on the 13th of June, but the solstice is coming up, and it's a lot of good energy on the 20th, so that's why I moved it back to the 20th.
So June 20th is the next one, and then July. One writer says 6 weeks is a great idea. Another one says every 6 weeks is good. This allows others to refresh with the previous webinars. And then another one says monthly is great. Another one says, I agree, every 6 weeks is great. After the RV, more questions, monthly.
Yeah, well, I don't know. I'll be hard to find. I'll be so synonymousness that
then my people have to talk to your people. And
yeah, right. Yeah, well, we'll go, we're going to do it on the 20th, and then between then, Tanzan and I will, I'll give some idea of topics that I want to do, and we'll also make a decision on the 6 week or 4 week process.
Let's see, July 2, 3, 4, 5, 6. So 6 weeks from June 20th would be August 1st. If you want, that's a Wednesday, August 1st. We could skip the whole month of July, do August 1st, and then revisit the question at that point as to whether to resume monthly or.
Yeah, I like that idea. So we'll do the 20th, and then we'll do August 1st, and then we'll see how many people show up. It depends on where you live. You might be on vacation. You might have kids tugging at you to go into the water. And so let's wait.
And another writer agrees with an idea I had, which is to send out an email survey. So in a newsletter, we could ask the same question.
Good idea.
Yeah. Okay, so everyone, June 20th, we'll meet you again. And then August 1st, we'll put it out in the newsletters. And we will go ahead and, of course, stay in touch in the meantime by all the means of communication already available to us through the website and phone. For those of you who are clients, you have direct contact with Randall. Those of you who are considering becoming clients, by all means, join as soon as you can. And we'll look forward to a rock and roll together. So
most of you have $250 you can start with, and it's not a hard row to hoe if you have any kind of cash flow at all. If you don't, then you just got to wait a bit.
Yeah, the $250 a month been working very, very well for more and more people who don't have $2,500, and those who have done it are very glad they did, because the RV is taking longer and longer and longer and longer and longer and longer. And meanwhile, they've got their trust paid off in 10 months. And sometimes people come into money they didn't expect. They go ahead and pay it off. In conclusion, for those of you who came in late listening to a playback, houseoffreedomtrust.com, or get the link from your affiliate, your referring affiliate, whoever referred you. Houseoffreedomtrust.com is the default URL if you don't already have a link, and that's with dashes between each of the words, house-of-freedom-trust.com. And we're going to June 20th for the next webinar, 2018, and August 1st. Then phone number 360-200-7521 for those who like to communicate like that. So Randall, very, very good. Thank you very kindly. We much appreciate everything that you've been contributing. And everyone else, thank you for participating.
Yes, thank you, Tanzan, and thank you for everybody that's joined us. It's I'm much better at answering questions than presenting material. So I just do a brief topic, try to touch on the main factors that are happening, and then put it out there because everybody's different and they all have different questions, and I really appreciate everybody showing up. Thank you very much. Aloha.
Okay. Aloha.